Hey, everybody. Welcome to
Hi, guys.
Hey, hi, Angela.
Hi,
What a
people.
day. What a day. I think we've
What
been
a day.
negotiating all
Yeah.
day. Actually, we've been
You know,
negotiating all week.
you know what it is? Like, I always use the Forrest Gump expression. Every day here is different. It's like a box of chocolates. So you pick up a chocolate, it's different than the next chocolate that you pick up. Every day is different here.
Yeah, but I only want one type of chocolate.
What type of chocolate do you like?
Well, I want a Malteser every single time
A
because
Malteser.
they're
Oh.
light and fluffy and they float away, you see. So that will make me light and fluffy and float away, yeah?
We can dream on.
Okay, so what we're talking about today is negotiation, right? Oh, bugger.
Did you do something?
Yes, I did. It looks like my my thing here has actually done the wrong one. Don't know why. Don't know why, but it's actually put the wrong thing into play.
Put the wrong banner in?
Put the wrong banner in, yeah.
Hmm.
Right. And I don't know. I don't know what's going on here.
Hey, guys. This is typical.
Oh, I see what's happened here. Somebody tipped up. This has all been screwed up because I've got a whole heap of rubbish in the middle of my thing. And okay, so now I can get the right description in there,
Yeah.
and we can then move forward with some sanity.
Yep.
Right, so here we go, the description. Tonight, we're going to be talking about negotiating legal claims.
Okay.
All right.
And now we've negotiated this little thing that we get through this.
So, okay, so there's probably, okay, so you were just saying just before we got online, yeah, all right, let's actually do a proper introduction. So, sorry. Welcome, everybody, to Spin Legal on March the 12th. This is Peter Giblett and Angela Browne. And today we're talking about negotiating legal claims. And if you need some advice, you should be contacting Invictus Legal LLP. And you can do so on 905-688-5598. Email Angela at weareinvictus.legal or me at peter@weareinvictus.legal. Of course, our webpage is at weareinvictus.legal. There you go.
Absolutely. Okay. We'll put some in the comment sections after, so we'll have that available for you later on.
Okay, and you know, everybody's been talking about the tariff wars recently, right? Especially most Canadians. There's probably not a Canadian that whether I don't care your position, there's probably not a Canadian who doesn't know there's a tariff war going on between here and the US. Right? I'm not asking for your position. I'm not going to defend any position about that where that's not part and parcel of where we are right now.
But what this is a start of the art of the deal. Okay. Yeah. The art of the deal down south.
But President Trump says he's an expert at the art of the deal.
And all he's doing is turning the world upside down.
Have you read the book?
Yes, I did. It wasn't even written by Trump. He had a
I know that
for him, and the guy who wrote it for him wrote an article about it.
Yeah,
interesting.
I can't say I have read the book, but I've read several ones about the art of the deal, getting to yes, etc., etc.
Yeah. I have another one that I just bought on negotiation and mediation, mostly called Bypass Court.
Okay. So some of the you know, if you're going to be looking at like non-legal negotiations, you might well be thinking about your business entering into a contract with another company or, you know, somewhere. And you might be thinking, well, I'm going to pick a nice place to negotiate. Good idea. Absolutely good idea.
Always, they're going to do something like that, get everything in writing.
Yep. And I've done a lot of negotiations with businesses over the years, and where I've been on one side or the other of a negotiation, and absolutely a good idea. And exactly what Angela says, get everything in writing. right?
Because
And
that way,
come up.
if something goes wrong, you
Yep.
take out the agreement that said this is how we resolve it.
And you might have listed out a dozen items and typed up 3 or 4 different potential outcomes to this negotiation before you go into the negotiation. At least that's what I did anyway.
Yeah.
But there's nothing like the little bit of pen to the paper, oh, you want that? Okay, we can deal with that,
Even when we were negotiating our partnership arrangement, when we developed the LLP, I mean, that was a lot of work, but we did it.
Yeah.
Right? Because that's something that you do. Right?
Yeah.
It's not like people think, oh, I don't need to do this. I just want to get into business with my best friend. But what happens is something happens and your best friend and you have a fallout. Well, what are you going to do? Right?
Yeah.
This happens. It's like Mr. Trump down south. He decided that as soon as he got into office, he was going to stick 25% tariffs on Canada and Mexico and 10% on China or something. And then just
didn't make any sense at all.
Now he's putting tariffs on other people too, with other European countries. And I just don't know. That doesn't make any sense. Okay? Some people who think they know Trump well, he says this is a guy, he's just trying to get something done, trying to get a deal done. And that's his way of doing things. Let's just go to the extreme and then we'll get something more reasonable. Okay? But I don't know.
I get it.
It may be true, but it's just it's putting a lot of people up in arms.
And okay, that may well be true, and that may be Trump's style. But at the moment, we've just seen 1.75 trillion wiped off the value of United States stocks and shares.
Yep, exactly.
Right? That's what the news is saying today. Al Jazeera, who my colleague on Talking Niagara swears by because he says they're independent. They do their fact checking. So I believe that they probably fact checked that. So they've totaled up the total number of losses, and they're saying 1.75 trillion.
Trillion. And that's
trillion.
God.
With the T.
Yeah, with the T. Not a B.
With the T. Yep. Anyway, okay. So in terms of picking, you don't always have the best choice for how you're going to pick your negotiation. It's not always up to you. And for example, if you're in a union negotiation or something like that, in fact, actually, the choice could be anywhere but good.
Yeah.
Right. You negotiate, think of this as you're negotiating your way out of the sewer trap.
Yeah, exactly. Or you're in a situation where you have a lawsuit, say, against your employer, right?
Yep.
And your employer's trying to be very stubborn, and then you're ready to go to court. And then the employer comes back and says, okay, I don't want to go to court. Because now we know what employment claims a lot of times end up with in terms of high severance entitlements for employees that are dismissed. So a lot of employers might like to just try to do the art of the deal. So that you don't go to court, don't get named publicly and all that other stuff. And then you get an NDA at the end of it and everybody's happy. Okay. So you get into a situation like this, and then like the employer didn't ask for the lawsuit, the employee didn't ask to be terminated. I mean, but you get into this situation and said, okay, now we have to make a deal. We have to make ourselves whole in some way.
Right? And no matter how righteous your position is, and there are always two sides to any coin.
Exactly.
Right?
Exactly.
You were representing an employee this afternoon who believes he was wrongfully terminated. The employer on the other side of the situation believes that they acted 100% lawfully. And the truth of the matter is somewhere down the middle. And at the end of the day, you probably don't want a judge or an adjudicator deciding that.
Yeah. There are reasons why you don't always want to go to court.
Yeah.
Okay? Because sometimes if you're an employee and you want to go to court, because I'm taking my employer to court, sometimes what happens is when you go to court, you lose control. Okay? You lose control because there's another side to the picture who gets to be heard just as much as you do. And they also have legal representation, just like you do. And they're going to cross-examine you all up and down and pull every skeleton out of that closet that they can pull out.
Yeah.
And this is why sometimes you do not want to go to court.
Yeah.
Okay? Sometimes you do. Sometimes it's best to do that.
Well, sometimes you have to, right?
Yeah, sometimes you don't have a choice. Okay?
And by the way, for everybody, I've given here, I did a search on this negotiation do's and don'ts, right?
Mm-hmm.
And the list of associated do's and don'ts is what is actually on display on the list here, right? So that's what I've come up with from this list, and I picked them up from the website. So if you disagree with something, it's not me you're disagreeing with, feel free. Right?
Yeah, these are things that are, and the very, very best thing about negotiation and mediation type of arrangements is because, first of all, you're spending less money.
Yeah.
Right? Like, even though you still have to have your legal representation and you still need to have some time to work out the legal details and stuff, sometimes you have to actually file before you can get in, and that sort of thing. But it's better than having 3 days of a hearing and then at the end of the day pay somebody else's costs.
Yeah, I was just going to say, consider you're having a negotiation, even if that, the negotiation, let's say it's somewhere between 2 and 6 hours, right? So you think of that in terms of the amount of money that you're paying in your legal costs right now. So somewhere between 2 and 6 hours. That might seem a lot of money in what you're laying out in order for that negotiation to occur. But consider that the alternative, once you finish your negotiation, which is that you're going to spend maybe 2 to 6 days in a courtroom, right? And some cases could be longer. Commercial. I attended a court case in the UK where they were in the Superior Court, and the box, basically the boxes lined up end to end in this courthouse. I came in as an observer because it was a commercial case. Ooh, and they were on the 4th month of this trial.
Yeah.
Right. 4 months into it, and the plaintiff case is still flowing.
Oh my God.
Yeah. So consider that. Consider the negotiation on that. And I'm not saying most cases don't go anywhere near 4 months. Even in the Superior Court, most cases are not 4 months long.
Yeah. And even on the average, if you're going to court on, say, for a 2 or 3 day civil trial, it's about $30,000 to $40,000.
Yeah.
Okay? And you don't want to do that. Okay? Unless you have to.
Yeah.
Right? Because sometimes you have to. You have no choice. Because otherwise the other side's just, because they're not budging or whatever. Yeah. There's often a reason why you might end up having to. Or there's a personal injury involved and you have to take that because you're required to claim that through your insurance. So there's a number of different reasons why people end up having to go to court. And yes, I have gone to court for many things. I've had a 7-day trial in the small claims, actually. And
the judge, I bet, said, Miss Browne, this is small.
Yeah, that was a different case. Okay? But this one was it was a 7-day trial. I won everything I asked for plus full costs, from the judge that awarded me at the time. Okay? And it was just went on and on and on.
Yeah. Okay. So those are kind of what you need to think about.
Yeah. Right? And you have to think about it and figure out to counsel how much this is going to cost. Hey, it's usually on a per day basis.
Yeah.
And on a per day basis, I charge more than I do on an hourly fee because I've got to get up, get nice and dressed up, prepare, get all my things out there, and
you mean to say you're not dressed up now?
Oh yeah, right. Dress business casual usually, but I usually have to get dressed up in a suit or whatever.
Yeah, I know. I'm just playing with you. You know that.
I know you.
Yeah. Okay. So we talked about the best time and place to negotiate, and hey, if that means going and consulting your astrological chart, please do.
Yeah. Yeah.
Right. But remember, you're not always in control of that.
Yeah, and and the nice thing about in negotiation and mediation is that you have some control.
Yeah.
Okay?
And always
You
think
have some
about what
control over the
your
outcome.
always think about what your next best alternative is. I
Yeah.
want A, B, and C. Well, can you live with D, E, and F? Yeah, maybe.
Yeah.
Right?
Because I remember one time I had a mediator tell me there's quite a few of us negotiating with this one party who was kind of doing his best to take advantage of a group of people, and each of these groups of people had representatives. I was one of them, and we all sat around the table. We were negotiating the prices of different things, sales of lots, property, and stuff like that. And I remember the mediator, he showed up. We all paid him. Everybody paid him a little bit because we were all participating in this mediation, and it was formal. This guy said, well, he says, at the end of the day, I will know if this mediation is successful. He says, I will know that because if everybody leaves with their lower lip on the floor, I know I've done my job. And I remember asking him, what do you mean? He says, because when you go through a mediation, you get some of what you want, but not everything you want. And the person who has to pay is paying something probably more than that they want to pay for, when they want to pay less. So this is something that often happens.
Well, not in all cases. I would tend to disagree with some of that. I do agree.
What you're negotiating too.
Yeah.
Like in a family court negotiation, you're not always negotiating about money. Sometimes it's about child access.
Yeah, exactly.
Yeah. So things like that. So there's
and again, that can be another one of those. If you're successful, if you go with the chin to the floor, I want total child, I want total child support. I want to keep them Monday to Friday, and he can have them every 14th Sunday. Right, that type of thing, and it's like that's an unrealistic demand, right?
Yeah, exactly. Or when you start referring to the other party as a sperm donor or something else, which is not a very good way to negotiate. It doesn't put you on a proper ground.
But again, what you need to do is come up with your best alternatives. So sometimes, as I said, you start with A, B, C, but you scale it down to D, E, and F.
Yeah, exactly.
Right? And there's a few things you're not going to get rid of, right?
Mm-hmm.
And hey, don't expect those you're not going to get rid of. Don't think about apologies within it, because legal cases are not about apologies.
Yeah, and even if they had apologies, it doesn't give liability. There is something called the Apologies Act. It doesn't give any liability to the person. They could say, I apologize, I'm sorry, but that doesn't make them more liable for something if they didn't apologize.
Yeah. And in legal terms, there's very little room for actually asking somebody to apologize.
Yeah, exactly. Sometimes they say, I want to make them apologize. Okay. Yeah, I don't think so. If someone's made to apologize, it's not really a true apology.
Yeah. And I've kind of said the way we make them apologize is through winning the money.
Yeah, exactly. And that's what the legal system does.
Yeah.
And there's very factors about negotiation, which is very important. It's that there's 4 factors which are very important. One is that the negotiation is voluntary. Yeah. Both parties, or more than 2 parties, are all agreeing to participate in the mediation and to agree with the negotiation or the mediation session, to try to bring their matters forward. Nobody can compel somebody who says, you're going to mediate or else. It
was actually, we were in a hearing the other week, if you remember, where we were actually down for mediation, and we had brief words with the other counsel on the other side, and through those discussions, we ended up resolving a couple of things. But through those discussions, we kind of came out of that little discussion for 20 minutes and said to the moderator, I'm sorry, but we're no longer up for mediation.
Yeah, exactly.
Right? And it was basically, we were talking about it at that point once we would finish talking, and it was clear to our client and the other side wasn't in a negotiating mood.
Yeah, and that's okay. You can't drag them to the mediation table, nor can you shackle them at the ankles and make them and make them mediate. Okay?
Yeah.
And
the other point,
the mediations are also informal and casual, where people try to discuss things in a relaxed manner. There's no rules of evidence. There's no rules that you can't go to the other side. You didn't follow this. You didn't file this in time. You can't do that. Okay. Basically, your mediation is outcome oriented. Okay. So you're looking at outcomes that both parties want to achieve out of this. Okay? So there's no rules based or arbitration based. Okay? And the two parties get together, often in front of a third party who's a mediator or some professional dispute resolution officer.
Well, actually, professional dispute resolution officers are good to have, because in fact, they can often, you hear the two parties speak. So party one says blah blah blah, party two says blah blah blah, and they both think, and then party one says, yeah, he's missing, party two is missing the point, and party two says, no, he's completely out to lunch on this particular matter. But the mediator has heard something in common, but you can both agree that
what I'm hearing is that you may not be in agreement on all the things, but I can see your agreement on the following 3 items.
Yeah.
Okay? And the person will list it. Okay? And are you in agreement with me that this is somewhere areas where you agree? And they're very good with that. Okay?
Oh, yeah.
Yeah. And the other thing, too, is mediations are confidential. They often make you sign a confidentiality agreement before you go forward.
Well, if you're going to a formal mediation, like if you come in to use our firm for mediation, you will get a mediation agreement sent to you weeks before the actual mediation takes place.
Yeah, because first of all, it says that it is confidential, that nobody is forcing you to do it, and that you want to come in to do the mediation, and also that it is confidential, and that basically you cannot disclose the results of the mediation, even if you don't come to arrive at a settlement. You cannot disclose that. So if you go to court afterwards, there will be some issues if you try to disclose what happened in your mediation.
However, that said, that may be settlement privilege, but at least if you go away from a negotiation that has not succeeded, you know something about what the other side's thinking is about, which may actually help you come up with a better settlement. I've had a couple of legal reps came to me the following day or the following week and said, Peter, I know we didn't agree on that particular thing last week. I think though my client's been doing some thinking. Maybe if we do X and Y instead of A and B, we can get to somewhere. And
I've had that too.
Yeah. So you
had
put
employment negotiations, and then they don't agree on anything. Yeah. And then a month or two later, they said, "Oh, hey, Miss Browne," it says, "I was kind of wondering." It says, "I was wondering if we could talk about this." And he says, "My client is willing to go a little further with this, and would your client appreciate this?" Hey, and that works, because sometimes you just can come up with it yourself, and it works that way.
Yeah. Oh yeah.
Yeah, and it's very important when you do these things, and it's also faster and it's cheaper. Okay, like I told you before, it could be very costly if you're going to take something to a hearing. Okay, like for us, it won't be 30,000, 40,000, but it may be more like 5,000 to 8,000 to 10,000, depending on the number of days of hearing. But we don't. We try not to get to a hearing if we could help it. Okay, but sometimes we do have to go to a hearing. I've had clients say, "Look, I want to go to court." Okay, and I tell them, "You know how much this is going to be?" And they said, "I don't care. I'll pay it," and they will go to court. But I always have them sign something so that they're clear about their instructions when we go into court, and they're also clear that they may be held with costs.
Yeah, that's an interesting thing, because I did that a while back, and I actually got I said to the client, okay, I'm going to have to write you a letter a relation to what your next steps are, and I'm going to have you sign an initial every part of this letter. And I will send it to you, but it'll be clear about how we're going to proceed to trial and on what basis. And and you have to know that the outcome may not be to your to your advantage, the outcome could go the other way. And at the end of the day, once I put this to the client, she spent the weekend thinking about it and said, you know what, Peter, I don't need the extra couple of thousand. I'm good where I am.
Mm-hmm. Yep, there are people like that, and but I usually make them sign and say, okay, I want to go to trial. I've understood, because I've always explained to them about the risk of having to pay the other side's costs.
Yeah.
Losing completely. Like there's different things that you have to explain to people, and also about sometimes public exposure in certain cases could be a problem, because your court cases are cited online.
Okay, there's another couple of things here to look about negotiation. What is your next best alternative? I think it's a bad thing to go into negotiations to be saying, I must have A, B, and C, right? Because A, B, and C are not not on the list, and it's rather like you and your girlfriend like the same record. You love the Bee Gees record, and you'll want that Bee Gees record. And she says, I'm not giving it up. And you say, I'm not giving it up. So do you know what the best place to do? Well, do you know what the best place to do is to bring it into here? And you see, there's a nice bin out there. I'll stick it in the bin. How about that?
Yeah. Yeah. Right? Or you can say, break the record in half, and each of you can have a half.
That was a Sufi by the name of Rumi actually had that idea, is that he had two ladies claiming that the child was theirs. He said,
Solomon,
bring me the child. Bring me the child, and I will divide it in. I will cut it into two, and you can both share. To which the real mother said, "Give it to her."
Yeah.
Yeah,
these are things that you always have to look at, when you consider that, about taking too strong of a position. I've had people, like I was once appearing at a human rights tribunal. My client at that time said, I want $1 million and I don't want anything less. And then we started arguing with the mediator and everything about this. And I tried to get him to calm down, and we took him out of the room a couple times and tried to explain to him, that there's a certain decorum you have when you're going into a formal mediation like this. But he was insisting that he had $1 million. I can understand. He was very, very financially devastated. He eventually did get a settlement that was reasonable, but it wasn't $1 million.
Yeah, of course.
But this is the kind of thing that you have to counsel your clients when you go in about approximately where. Look up some case law. Find out where the case law goes and where it's headed. What kind of arguments do you have?
Well, we have another situation, of course, and even there it's changing. Across the river, south of the border, there has definitely been cases whereby people have won tens of millions of dollars for certain cases, right? Mm-hmm. Most often, like product liability, somebody slipped from a ladder, or personal injury, or like the smoking claims, right?
Smoking.
Class action.
You do have a lot more mass tort litigation.
Yeah.
South of the border.
But again, it's got to be remembered that south of the river, even those are declining now. There's very few multi-million-dollar, unless you're scarred for life, there's very, very few multi-million-dollar personal injury suits successful anymore.
See, in Canada, we have some regulations put on of it, and it's been imposed by the courts. We can't get more than a certain amount. I think it's about $400,000 in pain and suffering type of thing. And then there's also other types of damages you can get, where like if you need care for life or something like that. So there's different types of things you have. But it's just that you can't go and ask for millions of dollars because I got a paper cut at work, so I'm going to go and ask for $1 million.
Okay. So going back to our negotiation points here, it says always leave room to negotiate, and give concessions slowly. Giving concessions slowly is almost okay. So your client's wanting $100,000 for their wrongful termination. My client says, I'll give you 2.5. Right. Mm-hmm. Now, your client when it comes back to your client says, okay, I'm willing to settle for 85. And my client says, I'll give you 2.5. Right? There's a point at which my client's being unreasonable.
Yeah.
Your client's being too quick.
Yeah. And you have to be careful because sometimes I do try to tell my clients, because sometimes they are a little bit over the thing. You make that as a first offer.
Yeah.
Okay? You throw it over the bow with the first offer. Okay? But after that, you start to find out what the other people say about it.
Yeah.
How they respond. Because it's very important to see how they respond, because they're giving you some important information.
Yeah.
Okay, about how you need to settle and how you need to sell your settlement proposals.
Yeah.
Okay. Because sometimes what happens is, sometimes they have very good points about why they don't want to give you more than so much. Okay?
Yeah.
And other times you kind of have to also say, okay, but my settlement proposal is backed by, make sure that it's backed by something. Just don't say, because I say so, or because I want it. Okay? No,
and there's another tactic.
Is important. Case law is important.
Yep.
Okay. Also, other issues where there were consequences as a result of the issue that you're negotiating about. Okay. And that sort of thing. Okay. And also look at non-monetary solutions too, to some of your part, because they can issue monetary solutions, but there's also some non-monetary solutions that could be very valuable for your client.
Yeah. And, there's another tactic in this regard that very often a lot of people will say, I'm happy to, I've got $100,000 claim. I'm happy to settle at $75,000. So therefore, what you're going into the negotiation with is $150,000.
Yep.
Right. Yep. So knowing, and hey, sometimes I'm kind of going, well, Angela's then coming into at 150,000, and I mentally take a note and say, okay, she wants 75.
Yeah. And I also have to take a note of where my client is, what position they are in.
Yeah.
If the situation has severely disadvantaged them for a very lengthy period of time, of course, I'm going to be on the cuff and I'm going to be jumping at it, because basically there is going to be more damages in terms of, if the person has been, there has been some difficulties, some inconvenience, some hurt in between, but they're still in a relatively easier position, then there may not be as much damages, and we could carry some flexibility there when you're parting with the other side. And the facts is, you have to put the facts on the table. Okay? What are the barriers that the other side is facing? Okay? Is that industry that employer in that particular industry, are they suffering particular constraints in that industry? Okay? And then you kind of show some understanding towards that. Okay? And because they may have some limits of what they can do. Right?
Yeah, and particularly if you're dealing with somebody who's got a disability. I lost my right arm. I no longer have full functionality in my arm, but I can use my index finger and my thumb. Right. So imagine I don't have the rest of the fingers there. They've been chopped off.
You can give people the fingers still.
They've been chopped off in an accident, right? So you've got to imagine that. And that sort of thing has to be shown in a tactful way, and shown to the shown to the people as to, this is part of the problem that you've got, is that yes, he can do this and that and the other, but he's now limited in capability because he's only got the finger and thumb on that hand.
Example
if you can accommodate
compensation. Hey, when someone gets injured and there's certain things, like I had a guy who lost fingers on both of his hands, and he had to have joint replacements on the remaining fingers.
Yeah.
And he wasn't able to do a lot of work with his hands.
Yeah.
Afterwards. And this was a guy, all he ever did was work with his hands all his life. He wasn't the type of person who could probably use his remaining fingers and be a computer programmer. He just didn't have that type of skill. He was always working with his hands. And this is actually, where you have to give that consideration.
And actually, that might
eventually got him his payments.
And that actually may be coming down to, what you can do. If you're a computer programmer, and you lose your ability, like you've got no way to type your computer programs anymore, you don't have that ability, that could actually severely, that ability can severely has a major impact, right?
Yeah, exactly.
But again, there's an important factor also to consider. Don't say yes too quickly.
Yep, I know one guy who did that, and I practically wanted to slap him. He was at a thing with me, and
It's
their
like,
first offer, hey, the guy said, "Oh, I like that," and he told him right up loud, "I says that's okay with me," and I just felt like slapping him.
well, it's like you've just lost, you've just had a fire in your house, and you've lost hundreds of thousands of dollars worth of equipment, and the insurance company says, "Here you are, $5,000," and you go, "Yippee! I'll have that."
Yep,
No,
exactly.
no,
You have to be
no.
very careful. Like I did sue before. I did sue an insurance company before, and because of damages in my house, they eventually paid, but not as much as I wanted. But that's obviously what happens. Again, it comes down to that negotiation thing.
Yeah, and there's one actually which I'm not sure that this one is actually a real thing. There's two sides to this one. Don't be the first to make a major concession. Um, um, the other flip side to this one is don't be the first to put money on the table.
Yeah.
Right. But in fact, actually, sometimes you can make a major concession without losing, and you can put money on the table without losing.
Depends. You have to judge the situation. This is
Absolutely.
why people need to seek legal advice, even if they want to
Yeah.
go through a mediation or that, because first of all, we're familiar with the case law. We're familiar with what people are likely to pay out. And also during the process of negotiation, I can tell them whether they seem to be getting a little further ahead and maybe become more helpful, and whether they have bigger pockets.
Yeah.
Because
And for example, one of the things you may well have two identical cases whereby, in one particular case, the person involved in the case who's doing the negotiation because he lost his minimum wage job, so he gets $250 above minimum wage. And he's going, yes, I'll have that right now. A year's worth of salary at $250 above minimum wage, I'll have that right now.
Mm-hmm.
Right. But yeah, you've got another person who will go back to the computer programmer on a good salary, injured, and they say, yep, we'll give you $250 above minimum wage for a year. It's like, not a chance in hell.
It's snowball's chance in hell.
Yes.
Wasn't that said recently by somebody? Not a snowball's chance in hell.
Probably the amount of negotiation that's going on in the world today, that more than likely,
something like becoming a 51st state or something like that.
Yeah. And given everything that's going on in the world today, I wouldn't be surprised that statement has been made recently.
Yeah.
And the point being is that it's about the position. Now, I was talking there about two different people doing two different jobs, suffering the same injury.
Yeah.
Right.
And again, the circumstances of the jobs.
Circumstances of those jobs make the difference in terms of what they will get.
Yeah. That's the same as my guys, who still had the use of some of his fingers, but not all of them. But he couldn't use his hand for what he was used to doing. He was doing bricklaying, he was doing labor, he was doing a lot of that stuff, but he couldn't do that with just the way his hands were. Although if he were trained as a computer programmer, I guess he could figure it out. But it's just that he wasn't able to do that. He didn't have that.
Well, I was going to say, go beyond a computer programmer, Angela, who's just a keyboard jockey at the end of the day.
Become a politician.
Well, that's true. But I was actually thinking, is that they're a concert pianist or a rock musician.
Oh, that's another one.
Those kind of people, and you think about where they are, and they who suffer such an injury, that's a massively different thing. And
violinist, I heard of a case about a violinist who had that issue.
And
couldn't play violin anymore.
A classical violinist who can't play the violin anymore uses she. I said she. It could be a he, of course.
Yeah. It was a he that actually lost their ability to play the violin, and like that could be very significant in terms of damages.
Oh yeah.
Okay. Whereas I can't play the violin anymore. Well, first of all, I don't know how to play the violin in the first place.
You play the miniature one, don't you?
Yeah, I play the smallest violin that I could get for a lot of people. That's the only one I know.
But you see, Angela, I come from a family where my mother played the violin all her life, and my brother could pick up any instrument and figure it out in about 2 minutes flat and play concert level music in it.
Mm-hmm. Yeah, that seems to be a gift. Ben has that.
Yeah.
Hey, and some people have that, and then I don't have that gift, but I can sing. And you told me that you can play drums.
I can play drums, yeah.
So we should have a drumming session and I can sing.
Yeah. Okay, so don't make those concessions, don't. Well, that's what they're saying. I don't know that it matters. I think
depends on what it is. Okay,
you need to get
forward with a certain concession because this is how we got the Cold War ended, because one side made it a unilateral concession, and that's how it ended.
Yeah,
right? Because that also encouraged the other side to start making concessions.
Well, and it was if you think about the fall of the Berlin Wall, right? The fall of the Berlin Wall. If you were living in East Berlin, you could not get within 20 foot of that wall, because everything down the eastern side of that wall had been eradicated for at least 20 feet. So if you stepped over that line, you could be shot. Yet there was the day when the Berlin Wall came down. Not only were the people standing on the wall, there were people pushing it in both directions.
Yeah.
Right? Major concessions were made by the soldiers in East Berlin.
Yep. And also when they made negotiations, Mikhail Gorbachev and Ronald Reagan. That was the first when they started doing it. One of them gave a major concession, and then they said, oh, okay. That was unilateral. There was no expectation on the other side. But then that started the conversation going. And that's a very interesting.
There's a key factor there, of course. What we're talking about here? Talk less, listen more.
Yep.
Right? And that is key about exactly where we are right now.
And you can learn about situation more. Like you're listening to your other side. They're talking about why they are taking the position they are. Yeah. You may not agree with them, but it's important to listen to them because especially if you're counsel to counsel, there's always very important things for them to say and for you to hear. And it also helps you in your own strategy when you're trying to back your own position.
Yep. Yeah, absolutely. And to be quite honest, where we sit in any situation, I think listening is a vitally important part of legal discussions, generally speaking. Right?
Now it looks like, what's his name? Zelensky from Ukraine. Hey, they finally got him to agree to a 30-day pause on fighting. Hey, but now they're trying to go back to Russia to see if they will agree to a similar 30-day pause.
Yeah.
Hey, so I haven't heard yet whether they will or not, but I hope so. Maybe they can start stopping this craziness.
Start stopping it, yes.
Yeah.
I agree. Okay. So in the case, it's also a case of talk less and listen more.
Absolutely.
Right. And in fact, one of the things that I said, you remember when, of course, former Yugoslavia collapsed and there was civil war in much of former Yugoslavia. One of the things that I advocated therefore is, hey, we can solve this. It's about negotiation. You pick up we're not going to supply you with guns. We're not going to supply you with energy. We're going to cut your power off as much as we can cut your power off from the outside. So you don't get gas, you don't get bullets, you don't get guns, right? But if you pick up the phone, if anybody in that country picks up the phone, they get the international negotiating team.
Yep.
Right? Don't care who picks up the phone, just pick up the phone, you'll get the negotiator. That was my solution to Kosovo and the like.
Yep. Mm-hmm.
Right? And I think it's about the negotiators there would be prepared to listen. They need to be prepared to listen.
Yeah,
and
exactly.
The only way you're going to
on the other side, because like even when the first thing, the CUSMA, the CASMA, when that was being negotiated, Canada, USA, Mexico agreement was thing. Of course, Donald Trump said, "Oh, this is a wonderful agreement. This is the best agreement I ever made," and now he wants to tear it up. But anyways, how that was done was very interesting. Because Canada went down.
I thought it was a bad agreement, to be quite honest, but still.
So what they did is there was a lot of talk back and forth, and they had tariff threats and everything else. And until at the end of the day, they said, okay, now let's go back, let's negotiate, let's talk. And they actually wrapped it up without continuing that at the time. And now we're back in the same position. So hopefully we'll end it.
I think it was a very bad agreement, and I'll tell you why. Because one of the big problems that is with the US and with NAFTA, North American trade agreements, and I will emphasize the word F in there. The F is free, right? The point being is that one of the best things that has happened in Europe was the free trade agreement in the European Union. There is no tariffs between nations on anything. And this has actually been one of the things where people in the UK have been saying, we want to undo Brexit.
Mm-hmm.
Right?
Yeah. And this is getting...
We want to go back.
Because our own person who's now running for prime minister, he's actually helped them tell them, he says, no, don't do Brexit, because this is going to be an economic disaster.
Yeah.
So they did Brexit. They found out it's an economic disaster.
Yeah. Oh, yeah.
Yeah.
I could have told them it was going to be an economic disaster 20 years ago.
Peter could have told them.
Yeah.
But some people, they're very determined. They want to do whatever they feel they need to do.
And again, here we've just covered some important points here. We discovered about why being skeptical is an important skill, right?
Yeah, exactly. Always question things.
Yeah.
If someone tries to sell you a bunch of facts, check them out.
Yeah.
This is why sometimes when we're working on different things, I remember when I was first starting in practice, I had one lawyer says, oh, they'll just go to court and they'll rip him apart, your client apart and everything. I looked at all that stuff and I went and did some research. No. I'm not confident. No, that's not going to happen. And in fact, I was able to negotiate a deal after that, because I questioned a lot of these things. I did my research and I went back to that same person and said, this is not true. Maybe we should talk again, and see what we can work out. And we did. And a lot of part of our law practice is negotiating and mediating. Well,
in fact, actually, the one good thing about, if you look at the way small claims court happens, and it's the same when you've got superior court claims as well. The money figure is different, but they actually have a standardized path for negotiation and a standardized path for once discovery has occurred, they've got settlement procedures in place in the superior court. So we have settlement conferences in small claims court, absolutely essential part. And unfortunately, there are too many people that go into a small claims with, I must have, or I'm not going to negotiate.
Yeah, they're self-represented people very often. And they have a vision of the courts that, like they see Law and Order or Practice or Boston Legal or something like that. They think everything works like that. And that's like everything gets resolved in an hour.
Yeah.
But the thing is, it doesn't work that way. It's so much more complicated. And the thing is, the self-rep will go in there and they'll say, oh, I just want this because, I just read in the newspaper that somebody got $150,000 for a similar claim to mine. And the person does not understand that $150,000 was awarded by the courts for quite different reasons than what that self-rep believes.
Yeah. Well, that's like what I said about the difference between the minimum paid worker and the person who's on $150,000, right? Even though you've got an identical injury, the actual award is based upon your earnings.
Yeah, earnings or yeah, exactly. There's a lot of significant, or the type of work, hey, because like as I said, the one who can't play the violin anymore and made a good living being a violinist.
Yep.
Hey, and now
and again, exactly. All of those sort of things, special skills come into place.
Yeah.
And being skeptical, doing your research is an important part of that. Okay.
Yeah, I had to do all of that stuff when I first started because, like, of course, I was always really confident. I just went forward and I just thought I'd do everything. Really confident. But then I started encountering people. I said, oh my God, do I really want to do this? And I said, no, let's just do my research and figure it out because everybody else has to do the research. Yeah. That's what I did.
So here's a bit about negotiation. It says, aim to be a super winner and find a better deal for all parties.
Yep.
It does happen.
It does, because that's what I was saying. Sometimes we'll work it out and, certain things, because sometimes people, it's in the other party's interest sometimes to end it in a negotiation.
Well, there was a case that I did, and people know that I used to be in the IT world. And when I trained as a barrister in England, I also trained as a mediator in England. I was mediating disputes in England. And one of the situations that I had was a software company that had failed to deliver some software. The client actually had used their software and actually hadn't implemented all of it, and they were in a situation whereby it was an awkward situation, right? And one of the situations that I said is like, okay, I turned around to the software supplier. I said, how much time do you need to get your software fully installed in this company? All right, let them explain where they currently were on the situation. And I then turned around to the other side and I said, okay, so what are you prepared to pay in order to actually have this fully, the rest of this, which has been negotiated here, we've been talking about here, what are you prepared to pay to get that installed? Right? We came up with an amount of money. It was extra money that the client, the software company's client didn't wish to pay out, but it was an amount of money that they were prepared to pay out. The other side was like, well, that's a lot less than we would normally do it for, but we want to get this business done.
Yeah. And sometimes you just want future business too. Yeah.
Exactly. Yeah. And that's exactly where they were, because this was a win-win for both of them, because this is the first time that this particular type of software had ever, to both of their knowledge, this was the first time this had ever been used in that industry. Right? And that actually, funnily enough, because that brings me on to another thing, that's actually where having a specialist negotiator can help you, right? Yeah. Because I, as a person who was aware of how projects like that are put in place, who was aware of the capabilities of what the software could offer, and was aware of the business advantages of said software. So I was actually in a much better position to help those people negotiate a deal.
Yeah. And then there were other situations where we do a type of mediation where it's more of a collaborative mediation, where the counsel and the parties appear together in a room, but without a third-party mediator. Okay? But we would sit down and negotiate. There was one time I did this where there was a common law couple who somehow split up, and they had to argue about what belonged to whom, and also some custody of the family pet, things like that go on. So we would sit down and talk about these things. Yeah. So I write on a board, these are items that we agree upon, and these are items that we don't agree upon. Okay? And then we would work on all the items that we don't agree upon one at a time. And we would just do it on basic issues management, where each side would talk about what was very important to them, okay?
Yeah.
And what outcome they wanted to see. And at the end of the day, we had an agreement about what belongs to each person, how
Yeah.
it was going to be delivered to each person, and how the family dog was going to be spending their time.
The interesting thing is about a lot of what we've just been talking about here is, do you notice how very, very few words we talked about the law says, right?
Mm-hmm.
We have been talking about that ability of the people in negotiation to come up with a solution that's not necessarily about legal steps, right?
Yeah.
There's always a legal element to negotiation, and it is always important that both sides understand the laws around it.
Yep, exactly. Because
Right?
sometimes you make a negotiated agreement, even in a landlord-tenant board,
Yeah.
that's outside of the framework of the
Well,
LTB, but these might include other things that an adjudicator cannot order.
Well, and a classic example of that one is the well-known situation about cash for keys. That
Mm-hmm.
you cannot go to the landlord and tenant board and say, Mr. Adjudicator, I want a cash for keys deal.
Yep. I want
Right?
$50,000 cash for keys.
And you'll see the adjudicator's hands go in his ears and say, I do not hear that. I cannot hear that. It's
Yeah.
not part of this. It's not part
Well, they
of
look
what I
at you
can
like you
do.
got three heads.
Yeah. But it is what you can do in a negotiation. It is what you can do even with a dispute resolution officer within the board. They
Yeah.
can finalize a cash for keys negotiation.
Yeah. They do all of that all the time. They advise people about it, and they've heard it all. Eh?
Yeah.
And the same as we had it. There was
Well,
one time that me and Peter were working on a case that involved a very high profile individual in Toronto who was a tenant and who was being basically
yeah.
that their home was sold and she had to move and there were issues around that. So we negotiated a very nice cash for keys deal, and the other side worked with us very well.
And
And then
and
we
the,
ended
the
up with a
interesting
written agreement. Everything was done, and then funds were passed.
And the interesting thing is about that, on first contact with the other side's legal team, they said, we want this and this and this, and she needs to be out by this particular date, and we're not interested in a cash for keys deal.
Yeah,
And what
but
did they do?
a cash for keys deal.
Yeah,
And it was
exactly.
and at the end of the day, it was an amicable agreement. We got along well.
Yeah,
Right? It
and
was just something
yeah,
where we kind of said like, hold on here. Right?
yeah.
It's something that we're trained to do. Like some people who are legal representatives are not as well trained in that area, but it's something that we're well trained to do because of our backgrounds in mediation and that sort of thing.
Mm.
Okay? You
And I
don't
like
teach enough negotiation in these schools. You don't.
yeah, I like negotiation. I do, because I think it gives you other options.
Yeah, it
It's
gives you
like,
other options. It
yeah.
gives you control, some control
And
over your outcomes.
for example, if that software deal that I was talking about just a few minutes ago, had that not been negotiated through a mediation, the court would have likely have said, okay, a software company, you give your client money back to your client because you failed to deliver. I don't care whether you've spent it or not. That's $1 million or whatever the amount was. I
Mhm.
forget the amount, but $1 million, give it back to the to the client. So the clients, you can no longer use this software, right? And that's essentially what a judge is going
Yeah,
to decide,
exactly. They can only look
right?
at the law,
Yeah, and
right?
and they will terminate the contract at this point, and this point it's the end of deal, and you've got to give everything back, or
Mhm.
it's got to all been ended, right?
Yeah, and you
Whereas
make enemies that way too.
yeah, exactly. There's nothing. And in fact, actually, the deal that
And
we
when a
broke, that I
negotiated
brokered,
settlement is where you can actually preserve a business relationship.
yeah. Well, that's exactly it. That's exactly what I heard. I had the software company said to me, it said to me, I like this company because they've got a lot of what we need. It's how we want to, it's the type of company we want to deal with in the future.
Mhm.
And the client and their client basically said to me, the first thing is, I like the software, but it feels to me like it's got holes in it.
Mhm.
Right. And so I said, okay, that's something I can work with on both parties. And I put
Yep.
that, I said, with both of those parties, I said, can I put that to the other party?
Yeah.
And they said, yes. Right.
Yep.
The point being is with that openness there, they were prepared to work and deal with something.
Yep.
And that's what negotiation's about. Can you
Absolutely.
come up with something that allows you to get through this?
Yeah, exactly.
Right?
Yeah, and it stops defeating the whole purpose, of what you did in the first place.
Yeah.
Yeah.
Yeah, exactly.
Like we very rarely go to court. We do
Yeah.
go to court sometimes. We do end up in court for some trials, but we don't go to court a lot. Okay, because most of the time we're able to come up with a deal that's reasonable to the client and reasonable to the opposing.
Yeah. Okay,
But
so I got another.
Go to court.
Yeah, I've got another question which probably ought to be asked here. So I think that when you're negotiating, I think that we probably, there's a question here that we probably ought to ask. And let's put this one up here. And what are the implications? Long term, short term, long term, medium term? Obviously, we're not talking about a deal here that's struck for 100 years. We're talking about a deal that has a specific
99-year leases.
Well, actually, the interesting thing is about this that if I was going to say to you, the oldest company in the world was started in 534 AD, what would you think?
I would believe you.
Yep. Well, the issue is, yes, it was. There was a building company in Japan that was created back in those days, and they have done some wonderful projects over the years. And that comes about by negotiation, right? Good, skillful negotiation. Absolutely. And do you think that in that 1,500 years that they haven't made mistakes? Of course they have.
Of course they have.
Right.
And every company that's worth their salt is going to look at that and it says, okay, let's do it better next time.
Yeah. And you know what the difference is between Japan and for example, what I've heard this week that Hudson Bay Corporation is actually thinking about folding up, right? And I think that's North America's oldest company.
And if that goes under CCAA, that's going to be another interesting thing.
Yeah, and that's something that, in fact, in reality, I'd like to see. Somebody needs to negotiate that. Somebody needs to keep that going. Somebody needs to actually turn that around and be looking at what the implications are to ensure that Hudson Bay Corp continues into the future.
Yeah, exactly. Because I think there are specialists in our world, in the business world, who only do that type of thing.
Oh, yeah.
Companies.
Oh, yeah, absolutely there are. And, so the whole difference between how we work in the West and how places like Japan work, and I can't remember the name of that corporation in Japan. It's Kugigumi or something like that.
Yeah,
and
you showed me that.
I probably massively mispronounced it. Kunjugumi, I think. Kunjugumi, I think, is what it's called. And I'm sure that my friend Adam Hyde will actually tan my hide if I got it wrong.
Yes, you'll tan your hide.
Well, actually, the funny thing is that he and I were both discussing that said company a few weeks ago, and you just got to think about the implications and the deals that have been struck there. But the deals are done over longevity of the company. What do we do to keep the company going?
Yeah, and a lot of times these deals were done by handshakes.
Yeah. Oh, yeah.
Okay? But nowadays, it's more important to have something written down.
Yeah. Yeah, exactly. And the whole point is that we're in the world of everything being written. Live with it. We have to deal with it. There are still handshake deals. Hey, farmers do handshake deals all the time.
Yeah. I know them too.
Yeah.
We'll exchange a bunch of chickens, and then you can do this for us. You
Yeah.
do the deliveries for us.
Oh, and it's like, yeah, can I use your Westfield to go beet on this season? I know that you're not using it, right? And maybe the negotiate or something like that. Hey, I need to graze my cattle on it.
Yeah.
Go right ahead.
We had a whole court case about that, and somebody was supposed to be leasing the land, but they didn't actually have a registered lease. And the person went on and started working the land, and then we went to court, and the only thing that person could argue was unjust enrichment. And there's only about a $4,000 implication on that. Yeah.
Well, in fact, the interesting thing I know from actually owning a farm is that if you buy a farm, it might well be in the hundreds of thousands of dollars, even in the millions of dollars if you got the right bit of property. But you rent a field, you rent a 25-acre field out, and it's probably less than $500 a year you'll get in rent.
Yeah, and this was very typical.
Yeah. Not a very large. It's
not a really huge. Like farming's not a huge thing unless you've really got some good crop or some good cattle or what you're raising.
Yeah, absolutely. All right. So negotiation, I think, is an important aspect about anything we do in life.
Yeah. The other thing we need to talk about is because I think that this is an important thing, and I think at some point we'll talk a little bit more and maybe talk about some cases about this.
Yeah, we can do that. But remember, next week we're going to do with environmental law. So maybe in 2 weeks' time we can talk some case law around negotiation. That will be a good thing.
Yeah, exactly.
So coming back next week will be environmental law.
Yeah, we're going to have a guest speaker there.
Yep. So just so you know, so if you need to contact Invictus Legal, we're available on 905-688-5598. Angela's at weareinvictus.legal, and I'm at Peter at weareinvictus.legal. And our website is weareinvictus.legal. There you go. Okay. All right. And Angela's favorite part of this show.
Oh, yeah. What you heard today on Spin Legal or any of our other shows in this series is not legal advice. So what we said today, it doesn't mean you can go in there and then, hey, call yourself a negotiator or a mediator, because you don't. It's just giving you ideas about how these things work. And it could be an option for you the next time you enter into a legal dispute. And you can work with your legal counsel to help you do that. But if you need advice and you want to do something, or you feel you have a legal situation and you're not sure what to do, or you have an idea what you want to do, but you're not sure how to go about it, contact a paralegal or a lawyer. Hey, hopefully you'll contact us, hey, and we can help you. But just contact any paralegal or a lawyer to make sure you're getting the correct advice and making sure you take the correct steps so that you can get your issues resolved.
All right, and have a great day, everybody, and we will see you again next week, usually about 6:30ish. I think we were a few minutes late today.
Yeah, because we had a lot of different things go on, and we had to deal with
in the office.
Some emergencies today.
Yeah, so we'll see you then, and have a great.